Welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I'm Chris Davis, and I'm presenting today with Pete Harrison from our Philadelphia office. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk in your businesses. If you'd like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is showing job availability in a post-Protz world. Next month, our topic will be course and scope of employment. Is the going and coming rule still viable, a viable defense in Delaware? So with that, welcome everyone, and let's get started. This is a pretty good topic to have today, considering we're having our third nor'easter, Pete, in the Philadelphia area, and that always brings storms and chaos and things like that. So this is a good topic. So what we're going to do today is we're going to review earning power disputes and the way they're kind of handled in Pennsylvania workers' compensation matters from a brief historical perspective. So we're going to look at pre-Act 57 cases, we're going to look at post-Act 57 cases, and we're going to focus on that element of earning power, which focuses on open and available jobs. And then we want to give you some recommendations that Pete and I came up with going forward about how to handle these types of cases. So, you know, the title is Living in a Post-Protz World, and Protz is certainly the case where the Supreme Court, Pennsylvania Supreme Court, recently ruled IREs unconstitutional. And what that did is basically throw our world into a little bit of chaos because we were really heavily reliant on IREs to limit the case, take them from a lifetime exposure situation into a 500-week situation. In Pennsylvania, you can get 500 weeks of partial disability, and then manage them by either settling the case or doing something else. So, Pete, how do you feel about living in a post-Protz world?
For employers, it's not a friendly world, Chris, I think. You know, the IRE was a tool that really helped to identify an employer's, self-insured, and insurance company's exposure in a pretty definitive way where you could predict pretty reliably that you were going to get a certain rating and limit it to 500 weeks. And then after that, if you didn't otherwise settle the case, labor market surveys were a pretty viable path to managing your risk further, using litigation, also mediation to resolve cases. And one of the reasons why Chris and I were thinking about doing this seminar is we wanted to give people little takeaways as far as what to do based on recent case law development. And we'll talk about the Dennis Smith case, but you'll see from our discussion as we sort of wend our way from Kachinsky to the present and back to Kachinsky, that the vocational traditional litigation path looks fairly untenable, gray, does not give you the predictability that you would like to manage your risk. And we have some recommendations on how to short circuit the process a little bit, manage your risk, compress the process. So that's right. The point of today.
And I feel also like Pete, you know, I feel sort of uncomfortable in this post-Protz world, especially in the context of, you know, if you're an employer. I mean, it's been 22 years since Act 57 was passed. Our process is a little bit different on how we handle cases now. I think in Pennsylvania, you've seen the rise of the compromise and release, settling a lot of cases. And I think the expectation for employers was based on certainty. It was based on settling the cases and moving them in a quicker and more efficient and cheaper manner. And I think post-Protz, we're living now in a world of uncertainty and perhaps more expense, and that is why we wanted to have this conversation today.
And I'd also add that, and we'll get into this a little bit, hopefully with not too much legalese, try to keep that at a minimum, but if you go back prior to Act 57, under Kachinsky, you really had to show a specific job being available. And then
Right.
the employee had to show good faith in applying. And Act 57, in large measure, came in with labor market surveys to try to clear out all the clutter that Kachinsky and all the cases leading up to Kachinsky
Right.
created, so that you have basically a system where we had labor market surveys to show that employment was generally available, and that was where we have been going. But as we'll show you, the courts have chipped and chipped away at this, and we're really almost back to where we started from.
Right. So in a general sense, before Act 57, we were governed by this case called Kachinsky, which was a 1987 Supreme Court case which dealt with job availability in Pennsylvania. So the typical fact pattern would be the claimant's receiving TTD benefits, there's an IME, that you get some kind of restrictions into a category like light duty, sedentary, medium duty, and you, the employer, can't make a job offer to the claimant. And what can you do then? What could employers do back then to make a job offer and to either suspend the claimant's benefits or modify the claimant's benefits? And Kachinsky was a case that came out from the Pennsylvania Supreme Court, and Pete alluded to it, but there was basically a four-part test, and within the four-part test, it was very, very complex. So you needed a medical change of condition, then the employer had to show evidence of an open job that fit within an occupational category like sedentary duty or light duty. Then the burden shifted, never a good thing to have shifting burdens, I think, Pete. The burden shifted to the claimant to demonstrate that he or she followed up in good faith on these job referrals. And if the referral failed to result in a job, then the claimant's benefits, the TTD benefits, continued.
And if you think that's complicated, it was, because I think, and this is just my view, and I'd be interested to see what you have to say. The legislature didn't step in with any type of specific test, so the courts were basically given free rein to graft over time a specific test. So Kachinsky really is an amalgam of multiple cases leading up to it, and so it's kind of like created like a Rube Goldberg type of mousetrap that you had to deal with.
Right. So by like the mid 90s, there were many, many, many cases litigated on Kachinsky and different parts of the Kachinsky, part 1, part 2, part 3, part 4. What is good faith on behalf of the employer? What is good faith on behalf of the claimant? What is bad faith on behalf of the claimant? And what it did was it led to a system that really got bogged down in a hyper-technical analysis. And we would take vocational depositions back then, and they were extremely long, they were very expensive, and the cases were in litigation, it seemed like forever.
And none of this was good for employers, at all.
And employers didn't like it. And what the employers did is they worked with their legislatures, and the Pennsylvania legislator passed an Act 57 in 1996. And what 1996 Act 57 brought in was they brought in the concept of earning power assessments. The labor market survey under the new section 306B2 of the Workers' Compensation Act. And as Pete kind of alluded to, this was meant to cut through the clutter of Kachinsky, to make it easier for the employers to show work availability. And the general idea was that the employers were only obligated to show work generally available in the usual employment area.
Right, and basically, I think the legislative intent was for the vocational counselor to come in and present a snapshot of what was generally available, and that was good for employers because that gave them some quick guidelines on how to manage their risk.
Right. And it wasn't easy to get into the labor market venue. You know, the employer still had to show that there was no work available with the time of injury employer, because I think the legislature recognized back then that it was a little bit easier if you're going and doing these labor market surveys. So they tightened up the entry point, but still allowed us to do these labor market surveys. And for a period of time, labor market surveys were regularly used in Pennsylvania. I mean, you know, we're going back, 22 years. And I remember in the late 90s and the early 2000s, a lot of these cases were getting worked up and done as labor market surveys, and we were getting them in. And the system, I think, is in a general sense, was working with the labor market surveys.
I would agree. And then the Phoenixville Hospital case comes
Right.
and throws everything into a panic.
Right. So let's look at that one.
This is the part of the seminar where the PowerPoint's not working, so we have to ad lib.
I know. Oh, there it is.
Good. All right.
So I called this slide the retreat, and what Phoenixville Hospital was a case that was decided by the Supreme Court in 2013, which, in my opinion, let the air out of the labor market survey balloon. The Supreme Court grafted a sort of a radical interpretation or a radical change into the labor market survey system, in that they held that the jobs must remain open until such time as the claimant is afforded a reasonable opportunity to apply.
Right. And then what that said basically was that the claimants could come in and show that there wasn't a reasonable opportunity to apply. Almost, we're not sure, but almost like a rebuttable presumption that the work wasn't available.
Right.
And looking at why this happened is, I think in 2013 you had a different makeup of the PA Supreme Court.
Right.
And so the court looked at Act 57 and thought, this seems employer-based, and we want to flip it a little more to claimant-based. That's my sense of it.
Right. And no, I think that's totally right. The Pennsylvania Supreme Court did change around that time. There were different people on the Supreme Court, and they really started to take a look at, the labor market surveys, and they put this kind of hyper-technical analysis in place, which was basically that the jobs have to be open and available at the time the vocational expert conducts the labor market survey. That was number one. Number two, they must remain open until such time as the claimant is afforded a reasonable opportunity to apply. They never really kind of defined that in the case, which kind of spurs on the other litigation. And then if the job is filled before the claimant makes, or before a claimant has a notice and a reasonable opportunity to apply, the job doesn't exist. So this started the process of letting the air out of the balloon.
So, right. And then the next piercing, I think, was the Valenta case in 2017. Right.
So Valenta is a Pennsylvania Commonwealth Court case. Interesting enough, in that Commonwealth Court case, the court actually ruled in favor of the employer, but in so doing so, they tweaked Phoenixville Hospital and they expanded the burden of proof. And what it did was it allowed claimants to present evidence showing labor market survey jobs were not open and available. And in that case, the claimant went and he applied for all these jobs and he submitted applications. And he took the argument that simply by applying to all these things and not hearing back from the prospective employer meant that the jobs were not open and available. And ultimately, what the court determined is that claimants' applications for these jobs were relevant evidence that should be heard and considered by the workers' compensation judge, but were not dispositive. And what's the impact of that?
Well, I mean,
I think it opens up the can of worms, right?
Yeah, I think so. And then you could see the next case is the Smith case, which it arguably, although the court doesn't say it, but it arguably flips the burden to the employer to show that work is available.
Right. So in 2017, we have the tweaking, I think, of the burden of proof, where you have the claimants coming in, and really almost every case that you were seeing, they were going to apply for these jobs, and then you would have claimants' testimony that, you know, the job was closed, I wasn't available to apply, or I applied and I didn't hear anything back. And then Smith comes down, and that's a Commonwealth Court case. It's an en banc case, meaning it was decided by the whole Commonwealth Court. And in that case, there were 5 jobs located in the labor market survey. Claimant applied for all 5, and claimant received an interview for 2 of the 5 jobs. The workers' compensation judge granted the modification petition, and then the claimant appeals it up. And ultimately, the Commonwealth Court affirms on the basis that the claimant interviewing for the jobs showed that they were open and available, which I sort of like on behalf of the employer.
Right. So that by the claimant applying for the jobs, interviewing, it met the employer's burden.
Right.
So,
however, when we look at the specific holding, the Commonwealth Court said, we hold that a modification cannot be granted without evidence in the record that the specific positions remain open until such time as a claimant is afforded a reasonable opportunity to apply for them. The burden is staying now on the employer to show open, or openness, as I call it.
And here's the problem with that, because it is going to create a difficult burden for employers through vocational counselors to timely get reports out,
right,
to show that specific jobs are open and for how long. And a lot of times when the vocational counselor reaches out to employers, they're not always responsive to them either, and so it presents a real proof problem. And the other thing, frankly, that's going to happen is claimants' attorneys are going to tell their clients, don't interview for jobs, because by doing so, you help the employer meet their burden.
Right. So you're never going to see the fact pattern like you saw in Smith again, in our estimation. And what this kind of does is, you know, by placing the burden or keeping the burden on the employer to show openness, it really puts pressure on that vocational counselor, because typically what they were doing before, Phoenixville Hospital even, was they would find the jobs, they would do the labor market survey, they would send the labor market survey out, and that's really all they were doing until they were called to testify in the case. And then they would give an opinion about earning power as of the time the labor market survey was conducted and sent out. That's all different now. I think it's certainly incumbent on the vocational counselors to provide information and evidence to the court of what happens to these jobs after they're located and after they're put into the labor market survey.
Right. So the whole purpose of really reaching out to everybody today is to give advice as to what to do now. Now that we've given you the roadmap of where we are, we wanted to share with you our thoughts as far as what to do, how to really manage your risk in this post-Protz environment. And Chris and I talked about this a lot, and I think that going forward, reliance on labor market surveys are going to be fraught with a lot of appellate work, and these decisions are going to be appealed. They're going to go to the appeal board, they're going to go to the Commonwealth Court, they're going to the PA Supreme Court. When you're talking about managing your risk, the last place you want to be is on appeal, because it's costly, it takes up a lot of time, you can't reserve your risk properly. It's the last place you want to be. You want finality, you want to be able to manage your risk and get out of the case. And so where this Smith case is really a flashing red light to the defense side to say we really have to assess where we go from here. So one of my thoughts is that with respect to trying to resolve these cases where you don't have IREs and you really cannot reliably rely on labor market surveys and to go the whole route of litigating cases, I think that what we have both been doing for our clients is giving them a lawyer's analysis of earning capacity. So the way that would work is, from our experience in dealing with these things for decades, I think.
Decades.
I'll say that's true.
Don't want to date ourselves,
Yeah.
but we have been doing it for a while.
I already did, but I'll let people know that it's been decades. I know, but you know, we can analyze skill sets and we can analyze earning capacities and give a pretty good idea of where somebody's earning capacity is. And in terms of the vocational counselor, they definitely have a role. What an approach that makes a lot of sense to me is you can still refer out to a vocational counselor, have them reach out to claimants counsel, seek a vocational interview, possibly do the vocational interview, but at the same time, you're leaning on counsel a little more to say, all right, we think that this person has an earning capacity of X. And you can also lean on the voc counselor a little bit to give an informal opinion before they get going or she gets going and say, you know, what's your opinion? Can we have this tomorrow, not in 60, 90 days, 120 days, what the earning capacity is. And then try to formulate settlement recommendations at that point based on that, and then enter negotiations and also utilize voluntary mediation,
right,
or mandatory mediation as an alternative versus going through the whole process and then hoping for finality. In this environment, it's a little troubling.
Right. I mean, certainly when Pete and I sat down, you know, we wanted to characterize the problem. And the problem with labor market surveys is that, number one, they're typically very expensive and they take a long time to do. By the time the voc person gets the file, meets with the claimant, conducts transferable skill analysis, goes out and finds a couple of jobs, we're talking months in a typical case. So the labor market survey takes time, and during this time, we're continuing to pay the claimant indemnity, and we're continuing to pay the claimant's related medical bills. One of the problems with labor market surveys also is simply a judge reluctance to grant any kind of labor market survey. You know, we have some judges in the Commonwealth that will look at any attempt to use a labor market survey under a harsh light, and many times rule that the claimant's not even medically capable of performing light duty or sedentary, and throwing it out and not even get into these open and available issues.
Yeah, and you know, and the other problem, and you alluded to it earlier, if you're representing a large employer, it's almost impossible to establish that work isn't available somewhere. And
right,
the astute claimant's attorney really zeroes in on that as a weak point in the case. So the whole idea of relying on it as a tool to manage your risk, in my mind, is problematic.
It is problematic, and you hit on a great point, which is, you know, what happens when you thread the needle, so to speak, from a litigation standpoint, and you win the case, and you know the claimant's attorneys are going to appeal, and you're sitting at, you know, a year and a half, and what if, hypothetically, the case gets reversed, and you have to pay back due benefits to the claimant to make them whole, and interest, you know, and then you're back to square one. Again, that's another problematic thing. So I think your recommendation of allowing the defense counsel to work hand in hand with vocational counselors to kind of come up with a abbreviated labor market survey or an informal labor market survey to facilitate settling these cases via CNR is a good policy.
Yeah, and I think, you know, just boiled down, I think our collective recommendation is a non-litigated approach to managing your risk if you have somebody that is on benefits for a while.
Right. And I think that's step number one. You know, you work with the defense counsel, you work with the vocational people to put that framework in place and try to resolve the case through voluntary mediation. There's a lot of workers' competent judges now in Pennsylvania who will avail themselves to that. And if that doesn't work, then you always have, you know, you can always do the labor market survey and take it into litigation and, you know, possibly resolve it somewhere down the road. So, but I prefer, given the complexity of what's been happening with Phoenixville Hospital and the Smith case, and also, you know, the uncertainty of the post-Protz world that we live in, I think encouraging mediation and resolution as a way to achieve the goal of closing the case at a cheaper, quicker manner is the way to go.
Yeah, and frankly, to lean on defense counsel to give you ideas as far as what cases are worth in terms of what people can make. I don't think that it's rocket science in today's world, because there's a lot of public database information available to everybody.
Right.
And I think we should take advantage of it.
Right. And it was interesting. One of the things that Pete and I were talking about is, you know, one of the problems in determining, you know, what's a reasonable amount of time to apply and how long these jobs are going to be open. You know, in today's economy, as we sit here in 2018, the economy is a very active economy. Unemployment is very low at this point. The jobs aren't available as long as they were, let's say, 2 or 3 years ago.
That's a good point.
And I think that's even going to be harder in a hot economy, if you will, to utilize these labor market surveys effectively. If the economy changes maybe in a year and it cools down, you're going to have that greater window. But for the time being, these jobs are not sitting on the shelves like they used to before. And I think that even furthers our recommendation of trying to advance a non-litigation strategy to resolving the case, getting it closed, getting it moved for you and you know, your clients, the employers.
Right. You're basically relying on an appellate court or a judge to determine the economics at any given moment, and that's an uncomfortable position from an employer's perspective.
Right. So with that, I think we're out of time. I just want to thank everyone for attending, and thank you for attending our webinar showing availability in a post-Protz world. Next month, our topic will be course and scope of employment. Is the coming and going rule still a viable defense in Delaware? So Pete, thank you very much for participating in this with me.
Chris.
Always good to do these things with you.
And I guess people can contact us by email if they have questions.
Exactly. If you have any questions and you want to follow up with Peter or myself, contact us by email, and we're happy to respond and give you a call. And with that, thanks. Have a great day.
Thank you.